Good morning, this is your Kelso Report for Friday, December 7th, and I'm your host, Clark Kelso. Our first case today involves the fair cross-section requirement as applied to jury veneers. Then we examine the definition of a concealed dangerous weapon. Next, we'll consider the notice and filing requirement for making a claim against a state or local government agency. We examine the difference between a drug user and a drug abuser. And we'll close with a look at the kill zone theory of attempted murder. We begin with juries. The Sixth Amendment to the United States Constitution guarantees an impartial jury in all criminal prosecutions. One element of impartiality is the requirement that the jury veneer must represent a cross-section, a fair cross-section of the community. If distinct groups are systematically excluded from the jury veneer, the constitutionality of the composition of the jury may be challenged. The question, of course, arises, how does one establish that a distinctive group is so underrepresented on the jury veneer as to be unlawful? The Ninth Circuit has previously adopted an absolute disparity methodology, pursuant to which underrepresentation is measured by taking the percentages of the group at issue in the total population and subtracting from it the percentage of that group that is represented on the master jury wheel. Prior cases of the Ninth Circuit have permitted a disparity as high as 7.7%. In United States v. Hernandez Estrada, the panel faced a challenge to the jury selection process as employed in the Southern District of California. Although the panel found several irregularities in those procedures, it ultimately upheld the jury veneer because the disparities were below the 7.7% figure. In particular, Hispanics made up 24.6% of the wheel, and African Americans made up 3.5%. Comparing these numbers to the percentage of Hispanics in the Southern District eligible population, Hispanics were overrepresented on the veneer by 2.1%, and African Americans were underrepresented by 1.7%, neither of which is anywhere near 7.7%. Now, another way of actually looking at the numbers is that African Americans were underrepresented by 33%. Because you go from 5.3 down 1.7, that's a 33% drop. But under the Ninth Circuit's absolute disparity methodology, that is not how you do the calculation. You just look at the 1.7 differential. Chief Judge Kaczynski concurred without enthusiasm in the result, solely because he felt bound by the prior Ninth Circuit cases. And he advocates an in-bank so the court can adopt a more statistically sensible approach for measuring compliance with the fair cross-section requirement. And I agree with Judge Kaczynski. The rule the Ninth Circuit has now doesn't make any sense. So I expect we'll see an in-bank in this case in the near future. The Ninth Circuit also dealt with the question of what constitutes a concealed dangerous weapon. Section 46505 of Title 49 of the U.S. Code prohibits carrying a concealed dangerous weapon on an aircraft. The statute was challenged as unconstitutionally vague in United States v. Harris, where a passenger, having been turned back at a security checkpoint, successfully enlisted the help of an airport employee who was able to walk past the security checkpoint carrying the defendant's pocket knife, which had a blade almost 2.5 inches long. Once past the security checkpoint, the employee gave the knife back to the passenger who boarded a plane. Fortunately, another airport employee saw what was happening and informed security, who then boarded the plane and arrested the passenger. While the phrase concealed dangerous weapon might be rather vague in the abstract, the constitutional analysis of this type of an as-applied challenge is done in light of the actual facts presented. And that made this an easy case. The knife had a blade 2.5 inches long, the passenger had been turned back at the security checkpoint, and instructed to pack the knife in checked baggage or pay $30 to check the knife itself. So it was plainly a dangerous weapon. No vagueness here. Next, we turn to a case under California's Tort Claims Act. Now, whenever you sue government, you really need to remember that the procedures for instituting a claim are probably going to be different than the procedures for filing suit against a private individual. Moreover, since government entities are protected by sovereign immunity, and that immunity is generally waived only by statute, you need to make sure you comply with statutory notice and filing requirements, which are often construed strictly. That is what we see happening in DeCampley-Mintz versus County of Santa Clara, where the California Supreme Court unanimously held that the plaintiff had not satisfied the statutory requirements for giving notice and filing suit against the county. The case involved an allegation of medical malpractice against the county hospital. Plaintiff's lawyer hand-delivered a letter indicating the plaintiff was going to sue the hospital to the risk management department of the hospital. Unfortunately for counsel, Section 915 of the Government Code clearly specifies that a claim must be presented to a local public entity by, quote, delivering it to the clerk, secretary, or auditor, or by mailing it to one of these officials or to the governing body. You don't give it to the risk management department. A misdirected claim shall be deemed to have been presented in compliance if it's actually received by the clerk, secretary, auditor, or board. Well, the Court of Appeal in this case cut the plaintiff some slack, holding that a claim may substantially comply with the Act if it is given to a person or department whose functions include the management or defense of claims against the government entity. But the Supreme Court unanimously rejected this interpretation as inconsistent with the plain language of the statute. Next, we turn to this distinction between use and abuse. With certain substances, the law distinguishes between legal use and illegal abuse. Alcohol, for example. How do you really distinguish between lawful use and unlawful abuse? Well, with alcohol, we at least have one clear statutory test, as well as certain other less clear bases for making the determination. But what about the lawful use of marijuana for medicinal purposes under state law? Can that use constitute an unlawful abuse? In In re Drake M., the Second District faced this problem in the context of a judgment declaring the child to be a dependent of the court, based upon the trial court's finding that the father's usage of medicinal marijuana placed the child at substantial risk of serious physical harm or illness because of the father's abuse of drugs. The Second District disagreed with the trial court, holding that a finding of substance abuse for purposes of a dependency hearing must be based on evidence sufficient to 1. Show that the parent or guardian at issue had been diagnosed as having a current substance abuse problem by a medical professional, or 2. Establish that the parent or guardian at issue has a current substance abuse problem as defined in the DSM-4TR, which has a lengthy definition referencing a maladaptive pattern of substance use leading to clinically significant impairments or distress. The evidence in the case did not satisfy either Part 1 or Part 2 of the court's definition, so the declaration of dependency was reversed. We'll see if the Supreme Court leaves this one alone. Could have a very broad impact on dependency proceedings around the state. Finally, we look at the kill zone doctrine. Now, the age-old doctrine of transferred intent really gets quite a workout in People versus McLeod, where the Second District had to clarify and apply the so-called kill zone doctrine, a version of transferred intent, in the context of a series of charges for attempted murder. Factually here, the two defendants fired 10 shots from a semi-automatic handgun at a party at which over 400 people were present. 3 bullets struck 3 victims, killing 2 and injuring the third. The 7 remaining bullets hit no one. The defendants nevertheless were charged by grand jury indictment with 2 counts of murder and 60 counts of attempted murder. 14 of those were later dismissed, leaving you with 46. Defendants were tried together, but before separate juries, which convicted both of them of the second-degree murders, convicted one of the defendants of all 46 counts of attempted murder, and convicted the other of 46 counts of lesser-included offense, assault with a firearm. The jury got to the 46 counts of murder by applying the kill zone theory of attempted murder. The Second District reversed, finding error with the trial court's decision to instruct the jury on the kill zone theory. According to the court, the evidence was sufficient to support only 8 attempted murder convictions, the 7 bullets that hit no one, and the 1 bullet that injured one of the victims. As the court explained, the kill zone theory of attempted murder is reserved for those situations where there is evidence that the defendant intended to kill everyone in the zone, perhaps as a way of ensuring the death of the primary target. Only that limited theory is consistent with the rule in California that attempted murder requires the specific intent to kill, and the commission of a direct but ineffectual act toward accomplishing the intended killing. As the court noted, although the doctrine of transferred intent can support murder convictions if non-targeted individuals are killed, transferred intent cannot support attempted murder convictions concerning non-targeted individuals who were not killed. Stated another way, intent to kill does not transfer to victims who are not killed, and the kill zone theory of attempted murder must then be limited to be consistent with this rule. Accordingly, the kill zone theory does not apply if the evidence shows only that the defendant intended to kill a particular targeted individual, but attacked that individual in a manner that subjected other nearby individuals to a risk of fatal injury. Well, the evidence in the case did not go beyond that, so the court vacated the attempted murder convictions and remanded for further proceedings. And that's it for today's Kelso Report. Have a great day in the law.